at the local level. And that, while final decision is not defined in ORS 197-522, generally in the land use arena, final decision means the final decision, including all opportunities to appeal at the local level. And here, the hearings official made the initial decision. Two folks, both the applicant and the citizens, timely filed appeals, and so it would be the Planning Commission's decision that is final at the local level. If no one had filed an appeal, then the hearings official's decision would have been final. So it's my opinion that the decision is not yet final at the city level, and so the 197-522 would allow the applicant the opportunity to amend or propose conditions of approval. So that's kind of the first issue that came up. The second issue, the citizens noted that as part of the appeal documents, the applicant submitted a site plan but has not yet truly proposed amendments to the application or conditions of approval that would make the application consistent with the land use code. And that's what 197-522 allows the applicant the opportunity to amend or propose conditions of approval to make the application consistent with our land use code. This is, a bit of a timing question. The citizens are arguing that the applicant should have proposed those amendments prior to filing an appeal. As I read, and I don't know, Dan, if you have do you have the text of the statute that you could put up on the screen?
ORS?
Yeah. I may or may not have it for
I
you.
have 3B and I have the beginning.
Okay, this is great.
Okay.
So I don't see anything in the text of the statute that addresses timing of the amendments, before or after the appeal to the Planning Commission, except that the statute needs to be invoked prior to a final decision on the appeal. And I don't think we have a final decision yet. So, then there's some arguments about whether this is, we don't have amendments yet, but the possible proposed amendments are those, could those be more akin to a new application versus an amended application, and what does that mean? And again, I would just say that as I read it, there's nothing in the plain text of the statute that limits the scope of the amendments that can be proposed, except that they need to be proposed to make the application consistent with the land use code. There's an argument about the city being able to deny the application, and once the statute is invoked, the statute does allow denial of a land use application if it cannot be made compliant with the land use code and our comprehensive plan. And I don't think we are at a stage yet where we can say for sure that this application cannot be made compliant. And then the final issue is, the citizens just noted that if Planning Commission decides to kind of move in the direction of staff recommendation and provide more process related to the applicant's invocation of 197-522, that the citizens are requesting the same amount of process as they would be provided related to a new application. And I just wanted to note that staff's recommendation at least does that. I mean, staff is recommending a new public hearing, a reopening of the record, and the ability to appeal the hearing's official decision on remand should Planning Commission decide to remand the decision back. So I just wanted to kind of daylight those issues because I know, at least at the last meeting, Planning Commission didn't have a lot of time to review the letter, and to make sure that there's an opportunity for discussion of those issues if Planning Commission so desires. So.
Okay. Does anybody have any comments based on the kind of explanation? And I would guess maybe even go so far as to say recommendation that you've kind of laid out for us as far as what your professional opinion of what the interpretation of how this might apply.
I would say that as far as the letter goes, I don't see anything in it that would change staff's recommendation, which you have in the form of the recommendation and the draft final order. Of course, Planning Commission could decide to do something different.
Okay.
But
All right. I'll take any questions or comments the commissioners may have on this letter. Okay. Okay, so it looks like we're then ready to proceed with issue number 3, which is where we left off. And I know I'm going to go ahead and allow for Commissioner Borofsky to start off in the queue if you want to have some questions answered. I know that was where we, unless there's an objection to that, and then I'm happy to put Commissioner Baker in the queue.
I did have a question for the,
Okay, yeah, go ahead.
so it was just a question of, let's assume that someone appeals the invocation of,
appeals of Planning Commission's final order.
well, yeah, I guess final order and related to this invocation of this state statute. And a decision is made that we didn't invoke it in the proper manner. What, I just want to get an outline of what the consequences would be or how that works out in the process.
It's a good question. As I said, I feel like a number of times last meeting, and I assume I will say again tonight, we don't really have a lot of information about how this works. This is the first time in my experience that the statute has been invoked in the city of Eugene. Like I said, I did some legal research, and there are some LUA decisions from a while ago, but not since it was amended in 2015. So we just don't have a lot of general knowledge about how this will work. My best guess is that if the Planning Commission's final order were to be appealed up to LUBA and LUBA were to say, yeah, for whatever reason, we don't think the applicant had the authority to invoke 197-522, they would remand the decision back to the city. What would happen then would depend in part on, how they framed the remand and what they told the city to do on remand. But my best guess is that we would then kind of step back into the procedural posture of a tentative PUD decision by a hearings official and an appeal of that decision. And so that appeal would then be in front of the Planning Commission based on the initial proposal by the applicant.
And so would the appeals that have been filed be re-invoked again?
Well, I'm sorry, Commissioner Baker, I interrupted you. I think that is related to what staff has identified as issue number 4, sort of, do we put them on hold? What happens to these appeals that are kind of hanging out there while we figure out how to do this other process? And so the staff's recommendation is that Planning Commission take an affirmative action to place those appeals on hold, with the thinking that if this were to go up to LUBA and come back and LUBA were to say, no, just process it based on the applicant's initial proposal, then those appeals could be reactivated kind of right from where they are now. If Planning Commission accepts staff's recommendation and we kind of step away from our code process and into this remand back to the hearings official, and then the parties would have the ability to appeal the hearings official's decision on remand, then the parties that have already filed appeals and already paid their appeal fees could just amend, kind of pick those appeals back up, amend those appeals so they make sense in light of the hearings official's decision on remand and move forward with those appeals. So,
Well, I was more concerned about the timing because 4 months for LUBA, maybe 3 or 4 months for the Court of Appeals, because I assume this would probably end up go to the Court of Appeals. The invocation, because it's state statute, it's not really, well, it just seems like it's natural that LUBA would punt it in some way. So say we reopened the record and we had new testimony, then what happens if it gets referred back? So now we've had a new hearing, new testimony submitted in regards to this application. What happens? I'm just trying to think through the process so we have a good idea of what we're,
I don't,
I was going to say, Commissioner Baker, I mean, doesn't some of that depend on how the commission ends up ultimately voting on these recommendations?
I think it does. I think, again, staff has done the best that we can to kind of try to think out different scenarios and come up with something that seems fair and reasonable to all the parties involved and complies with the statutes. But it's impossible, I think, to game out all of, everything that could happen. And so as far as I see it, one decision that's before the commission that I think at least there was a unanimous straw poll about at the last meeting was the timing that staff was recommending. So staff was recommending 6 months for the applicant to, for lack of a better, get their ducks in a row and propose those amendments or conditions of approval, and then 6 months for the city to process, with the thinking that during those first 6 months, if there is an appeal of this final order, that's at least enough time for it to get up to LUBA and get a decision from LUBA. So an option would be, if there's concern about leaving enough time for appeals, to extend that first time period, but Planning Commission did, at least on a straw poll basis, unanimously agree to that 6 months. And, there was also some discussion about not letting it linger on and on before the applicant has to propose concrete amendments or conditions of approval. So I don't know that that fully answers your question, but I think that's the best I can do at this point.
Okay. All right. Well, I'll go ahead and let Commissioner Borofsky answer or ask some questions.
Great, thank you.
Okay.
And I've got a few things that I want to talk about appeal issue number 3. And for me, this is, as the city attorney mentioned, this is the first time that we've had to deal with this. So I'm trying to wrap my head around, one, the process, and try and set a template for possibly getting more of these, because I think that we may see more of these in the future. And there's several questions that and hurdles that we jump over, and they may be different for different types of appeals or invocations of this statute. So my first one is the statute says that in concurrence with the applicant, it can be sent to the hearings official. Was that initiated by staff to have the applicant send it to the hearings official, or was that something that was mutually agreed upon? Just walk me through that how that we came to that opinion and how we got the letter from the applicant.
So just to be clear, it's our code that requires concurrence of the applicant.
Yes.
Not statutory. In my opinion, at least, it was staff had some initial discussions about what we thought made sense and was fair in terms of a process standpoint. And part of those discussions was noting that Planning Commission had the ability to remand back to the hearings official, and that based on the site plan included with the appeal statement, it appears that the proposed amendments could be substantial and would therefore require reopening the record, and that is something that is squarely within the hearings official's wheelhouse to hold public hearings and look at evidence for the first time. Not that Planning Commission can't do it, but you see it less often.
Right. Okay, and that's good. That got to where I wanted to go. But the reason that I was going to that hurdle first was, again, in upcoming ones, it may be a small adjustment, and to take it and send it to the hearings official, whereas the Planning Commission could do it. And the reason I say that is because if you put it into the hearings official, then that adds another set of appeals and another set of timing. And as we all know, timing can cost money on both sides. And it's a separate appeal, whereas if it was a small small adjustment and made it happen, and it could be we could open the record and the public hearing in front of this commission, that would be a final decision. Then if there is an appeal, it could go to LUBA, whereas if it goes to a hearings official, it gets appealed, it comes to us. If that gets appealed, it goes on to the hearings. So again, I'm trying to set a template for this process and help figure that out. The next question I had was, how flexible is the role of the Planning Commission in a situation like this? Because in the applicant's letter, when they thought that it was going to be put in front of the Planning Commission as the appellant body, the body that would decide, they came up with some questions that they wanted us to answer, policy-style questions. And this is something that I think I've seen in appeals in the past, where we've got neighborhood issues, we've got developer issues, and by the time it comes to us on an appeal, it's black and white. Does it meet this criteria? And I'm wondering if this type of if it came to us, would we have the ability to weigh some of those neighborhood needs against developer needs and make a decision at this body? For example, the number of trees as opposed to the number of buildings, and some of the policy questions that were spelled out in the applicant's letter. Is that something that this body has an ability to do?
So I feel like there are a couple of questions. I'm going to try to unpack some of those questions a little bit. But to answer the question about flexibility and ability to kind of get into questions more than you otherwise often can on appeal, I think there may be two parts to that analysis. One is, you're right, you most often function as an appellate body, so you are constrained by the record that's already been established. You are constrained by the appeal issues identified by the appellants, and you are constrained by the code requirements, the approval criteria in the code. If you were to act as the initial hearings body, so to do what the hearings official does, you would certainly have some more flexibility about, you may have access to more evidence, you may have the ability to, ask questions of more folks at the initial public hearing. And you wouldn't be constrained by those identified appeal issues. You could look at, all of the applicable approval criteria. However, you will still be constrained by the applicable approval criteria. And I know that there have been some discussions about, especially in the context of a PUD, wanting to have more information about specific building sites and other things that aren't currently required by the code. And so I think there are a couple of different questions there. One is, would acting as the initial hearings body give you more flexibility? Yes, but maybe not all the flexibility you would like. And I think to get all the flexibility you would like, it might be a separate conversation outside of a quasi-judicial application about code amendments and whether you think the approval criteria are really working in the way that we had hoped that they would. In terms of setting a template for more of these, or I guess I would just say, Planning Commission, in my opinion, is not constrained in future invocations of 197-522 by what you choose to do related to this application. You will see in the final order, both under issue 1 having to do with the timing, and issue 3, we tried to write the draft final order in a way that made it clear that the process that's being proposed is specific to what we think is happening with this application, and what it would take to make this application consistent with our land use code. There may well be, as you pointed out, other applications where it's a matter of articulating one condition of approval, and that would be enough to make it consistent with the code. And so there would be no need for all of this process. So we wanted to make it clear that this process being proposed is specific to this application. I don't think that by adopting this process or whatever process you choose to adopt, you're tying your hands for future invocations of 197-522. And then a bigger question, kind of outside the scope of tonight's discussion, may be, I think you're right, there may be more of these. And so, is there, does Planning Commission want to talk about having a specific code process or some kind of specific requirements related to invocation of this statute? But that's a legislative conversation for another night, so.
So then,
Can I
go ahead.
interrupt really quickly?
Sure.
Because I just want to make sure that Commissioner Ramey and Commissioner Fragala had questions, and I didn't know if they were tied to this. If you wanted to go ahead and, okay, let me do that. Let me let them go ahead and.
So I think we might have already gone by my first question, but I'll try to back you up to that one. I can read here where EC 9680 allows Planning Commission to remand the application back to the hearings official. Is there a city code that says, or Planning Commission can just take it themselves? Or is that their only option that we have?
that's 190.
This is not the entirety of the code
Okay.
provision. This is an alternative that Planning Commission can do. So when an appeal is filed, it comes to you, or in this type 3 application, it comes to you, and you have the opportunity to, affirm, reverse, modify.
So there's more options than are just shown here?
Right.
Okay.
Or send it back.
Secondarily, if you're not to appeal, I promise this is my last question, then you've done your hearing and you realize, maybe this isn't going to go the way you want it to go. I'm going to invoke ORS 197.522. Where does that go?
So are you asking if
Before the hearings official has
has
issued an
issued a
opinion?
decision? As I read the statute, it just says before a final decision. So I
Right.
think it could happen anytime before a
Right.
final decision.
Right, but what happens to it then?
Oh, I would think that, well, it would depend
Back
on
here.
the circumstances,
And
but
we would have one of those options to choose from?
if it was within the, that's a good question. I think the recommendation would be if it's in the confines of a code process that, we could continue to move forward with. So if there were, you've had your public hearing, but the hearings official hasn't issued a decision, and I think at that point, we would just take a break, let the applicant propose amendments, the hearings official would consider those
Resubmit
amendments.
materials and just leave it with the HO?
Yeah, and then depending on the.
But who decides that? Does that come back to us to decide, or?
That's a good question. I mean, right now, I think we probably wouldn't bring it to you because presumably we could do it kind of within an already established code process. Part of the reason that we're asking you to make this call about procedure is because it just doesn't fit in the appeal process that we
Okay,
have right now.
thank you. That helps me. Sorry.
So yeah, actually, my thoughts were connected to some of what Commissioner Ramey was discussing. I feel like when we're thinking about this uncharted territory and what are the implications of the decisions that we make for any future referrals under 197.522, that the language that we're looking at both in the legislation and in the order are, allow us some flexibility, right? So Commissioner Borofsky, when you're talking about if something is really little and we want to make sure it turns around quickly, because I support that also, not dragging out these decisions for a long time. I think that a lot of the language, I felt like the language in the order was flexible enough that and clear enough that it applies to this decision, and that in the future, if or when we see another referral like this, we will be able to make similar decisions. Maybe we'll have a little more experience with it, but we'll be able to make similar decisions. So in terms of thinking about the implications of the decision that we're making, I feel really comfortable with a lot of the language that we're able to continue to have that flexibility in the future. And in terms of procedural issue number 3, I do really feel that the functions that are most attributed to the hearings official are the things that are going to need to happen. And so that's why I feel like it makes sense in this case to refer it back to the hearings official.
Thank you. And I agree. I think in this case, we've been given information that definitely lends it to landing in the hearings officials basket. The question I have is that we were given a kind of a heads up as to the direction that they were going to go. They didn't have to give us that heads up. And so the next question I had was, would it be appropriate for us to make that decision whether to remand it to the hearings official or keep it in our wheelhouse after we've seen the development proposal? Because in this case, we have an idea because they've given some sense of direction, but they're not bound to that. They've got 6 months to put it together, and we don't know what it is. We don't know if it's a giant, huge one, or we don't know if it's a small one. So would it be more appropriate to make the decision on number 4 after we've seen the actual development proposal, as opposed to saying, yes, it's going to be a big one, it's got to go to the hearings official, where they may come back and say, nope, we figured out a way to do the tree thing. Again, it's just a question, procedural question that we're being asked to answer here.
I will say that I'm not saying you couldn't do that. I think by virtue of the hearings official's decision that it was a denial, and it was a denial on a bunch of different issues, not just one, that there, regardless of whether or not the applicant proposes amendments that look like the site plan that was attached to the appeal statement, to make the application consistent based on the hearings official's sort of multifaceted denial, there are going to be big changes necessary to the application. And that being the case means that we're going to need to reopen the record. And that being the case, it makes some sense to me, and that's why staff is recommending to send it back to the hearings official. If in another situation, it might be different.
Okay, and that's what, again, I'm just kind of bringing these things up because it is a new thing, and I've got those types of questions. One of the last things that I'm going to bring up is the cost. One, the cost for the fee to do this. It said that the applicant can do it and pay a fee. And that fee was $400, as best as I could see it. I'm concerned about that, one, setting that as a precedent, because $400 won't even cover the cost in this room right now of staff. So I'm wondering, one, where was that fee derived from? Because I didn't see it in the city's fee chart. Obviously, there's not in the city's fee chart. Was that fee imposed with an administrative order out of Chapter 2 by the city manager's office in the way that fees need to be put into our code? Again, I want to make sure all the T's and I's are crossed, because sometimes if the I's and T's don't get crossed, like we saw in another appeal issue, they come back to bite us. So questions there. And then just, those are the questions. And then the third thing is, should at some point the Planning Commission make a recommendation to the City Council about a way to codify this and get the fees that are actually, incurred?
So I'll look to planning staff for help about the name of the fee, but it is adopted. It's in the adopted fee order, which was adopted by the city manager pursuant to Chapter 2. And your question about whether the fee really covers the process, it doesn't. And that is, I think, outside the scope of this discussion, but another issue which I see, me personally, related to invocation of 197-522, if this is going to happen on a more regular basis, whoever is appropriate, whether it's staff proposing to the city manager, or, some discussion might be appropriate about the right fee that could be associated with that.
Thank you. And thank you to the commission for indulging me on these types of questions.
Commissioner Baker, you had a question?
Yeah, I have some questions on the fee as well, but I just wanted to state for the record that I think it's more appropriate that we refer these complicated land use decisions back to a hearings official to take all this information. None of us on this planning commission are land use experts. We don't really know state statutes or even our local code all that well, except what's brought up for us. We're good at reviewing things that are brought up to us, but we're not a good body to review a sort of a blank slate. So I wouldn't feel comfortable if we were to take on these kinds of cases. I don't think the Planning Commission is the right body to take on these cases. It should really be referred back to a neutral party that is a land use expert, which is what we hire the hearings official for. And again, related to the fees, that's my concern. So there's a $400 fee to invoke this. No?
No, the $400 fee has to do with the remand back to the hearings official. So the remand is contemplated by our code, and we do have a fee associated with that. The invocation of 197.522 is contemplated neither by our code nor by our fee schedule. And so we don't have anything that it specifically attaches to that.
Okay, and so again, what happens, so the entire cost, the applicant has to pay $400, the appellant doesn't have to pay any money to get remanded back to the hearings official. Now, what happens if the hearings official decision is appealed? I mean, because we've already had I'm just concerned to appeal the hearings official application, the applicant and the appellant have had to submit additional funds to pay for that appeal. So now what happens in this case is, I mean, I just want to understand,
Commissioner Baker, well, that again is, I think, addressed in issue number 4, but I can briefly respond.
Move forward to that. I just want to put a couple of thoughts that in reviewing everything, because I actually do understand where Commissioner Borofsky is coming from in the sense that when the hearings official makes a determination and it comes to us on appeal, we have a very small scope of what we can actually look at and what we can influence. And, and I was reading our bylaws just for fun. And there, in Article 2 in subsection of C, it does say that part of our role is to cooperate with private developers and public agencies in an effort to provide adequate supply of housing for low-income families. And so that is a role that is difficult to do when we have this very small sliver of what we can be looking at. Having said that, I do support staff's recommendation on how we would move forward with procedural issue number 3, but I do understand where you're coming from, Commissioner Borofsky, in that to be able to have a little bit more authority on how these things are implemented and looked at. This particular case is, I would agree with the direction, but there may be a situation in which whether it's the timeline that would be and the time and cost accrued that would be added to something. So I appreciate that being able to take it on more of a case-by-case basis is sort of where we're at. So was there any other, Commissioner Beeson?
Yeah, so with respect to issue 3, and assuming we're going to take a straw poll on it, I'm also going to support it. I think I concur with most of what has been said here in terms of putting it back to the hearings official for the reasons that have been stated. I think the idea of it aligning more with the normal procedures and the normal way these things are done makes a lot of sense, as opposed, and given we've heard a number of times this hasn't happened before, or this is new, and I think it makes some sense to do it the way that everybody who's involved in this, all the different stakeholders are the people who have an interest of a process that they're used to or understand. It's just going to, whether it's the neighbors or the applicant or whoever, it's just going to be better all the way around. So I'm going to support it.
All right, well, I think we're ready for a straw poll. So on procedural issue number 3, all those in favor of the staff's recommendation? Any opposed? All right, there you have it. Oh, 6 to 0. Sure, Commissioner Fragler, go ahead.
And I know Commissioner Taylor is not here tonight and that she is not able to vote on this, but at the last meeting, she did express her support for procedural issue number 3 and number 4.
All right. Well, then let's go ahead and move on to procedural issue number 4. Do you have anything to,
You want me to, well, number 4 was, we had 2 appeals filed, one by the applicant, one by the Neighborhood Association. With the applicant invoking ORS 197, theirs is simple. It says, you know, you're going to get more time. So theirs is kind of put on hold, but we were wondering, what do we do with these appeals? And now that we have a second one, what do we do? So in the sense of fairness, as we've been trying to talk about this and get to that stage, we recommended putting them on hold. That's the fairest thing that we can think of. If it goes back to the, as you just kind of voted, goes back to a hearings official, if we get a project that can go to them, if it gets appealed from there, then it would be back up to you. We've written in here that they would just have to up their appeal, and it would bring them back out of that holding pattern, if either one of them. So that's kind of where we got on this one. I will let you guys discuss that ability.
all right, I have a question, but I'll go ahead and start with Commissioner Baker.
Yeah, this is where I was concerned about fees. So do we refund their fees for the time being? Because what happens if they don't appeal after the decision by the hearings official?
And we had that conversation with the planning director, and we've said that, especially with the neighbors, they haven't got a say in this yet. They could ask for their appeal now, or they can have it on hold in case they need it at the end of the second one. If they are pleased with what happens at the hearings official, then they wouldn't have to appeal it, so they would get their money back. I think we were, I'll look to Alyssa to.
Yeah, I mean, what we discussed is, one, making sure that nobody has to pay 2 appeal fees to the hearings official. That doesn't make sense. And so the ability to put these on hold means that the appeal are still live, the money is still, you know, it's been submitted, the fee wouldn't change on an appeal. So this gives them the ability to say, hey, we're actually happy with this. They could withdraw their appeals, either party, or they could resubmit additional appeal issues once a hearings official's decision's been made.
So if they decide to not appeal, we return their funds?
They asked to withdraw that appeal, correct?
Okay, that's what I was concerned about. I just didn't know what would happen if we were returning the funds beforehand, now, or holding it and then returning it later if there isn't an appeal.
It's really up to the parties how they want to deal with their appeals and appeal fees, and we didn't want to dictate that for them, but we did want to set up, as planning director mentioned, a situation where no one would have to pay a second appeal fee for because if things go the way we think they will, this appeal, the appeal issues will change. Nobody's really getting anything out of this appeal. So we want to give them the opportunity to change their appeal in response to whatever the hearings official may decide on remand, but not have to pay a second appeal fee. And by putting it on hold then also, as I mentioned before, we were trying to kind of plan for the possibility of a LUBA appeal where LUBA says, sorry, no one should have invoked 197-522 in the first place. I don't think that will be the outcome, but it's a possible outcome. And so then the appeals are still waiting if it does come back to you.
Commissioner Borowski and then Commissioner Ramey.
Again, uncharted territory. So the question that I have is, I see in the final order and I see in the record where the applicant has agreed to a longer period of time. But I don't see anywhere in the record or in the findings that the Laurel Hill Valley has agreed to that. And when it comes to the appeals in 9.7660, it says, unless the applicant and the appellant agree to a longer period of time, the planning commission shall hold a hearing to hear oral arguments on the appeal within 45 days. So again, I looked through the code and I didn't see anywhere where the authority was given to put it on hold unless the two parties that have appeals in front of us agree to a longer time frame. So am I reading that wrong, or do we need to get a letter from Laurel Hill Valley that says, yes, we'll wait until we see the new one? Because the way I read it, we've got 45 days from December 4th to hold a public hearing on at least on the Laurel Hill Valley's appeal issue.
So if Laurel Hill Valley citizens would like to give us a letter wherein they say, fine, hold off, we would certainly accept that. At this point, it is my conclusion that by invoking 197.522, we can no longer comply with our code requirements. There just isn't, we can't move forward with our appeal process in the way that is outlined in the code. And so that's in part why we're coming to you to ask you to adopt this separate process. And part of the thinking behind asking you to adopt this separate process, as we talked about at the last meeting, is that we believe that it is a final appealable order of the Planning Commission. So if a party is unhappy with the process that you have chosen, they could appeal that up to LUBA and say, city should have complied with its code. 197.522 doesn't apply, et cetera, et cetera. So we are trying to set it up in a way that even though we are deviating from the process that's outlined in the code, that interested parties have the opportunity to comment on that deviation, to challenge that deviation. It doesn't make sense to me to proceed with an appeal when we know that the underlying application will be changed. So if we continue down the timeline that's anticipated by our code, you could have a public hearing on one of the appeals but not the other. You're going to make a decision on the appeal that then the underlying application will change. None of that makes sense from a process standpoint. And so, again, this is our our best crack at the process that we think makes sense, is fair, is reasonable, and it may be that LUBA thinks differently, but we are trying to kind of do our best to make a good guess, to give you the tools that you need to have to make a decision about a process on this thing that we just don't know that much about, and to set it up in such a way that the parties have the opportunity to challenge it and don't have to wait for 18 months to make those challenges.
And I get that. The question that I have is, one, did we reach out to the other applicant and ask them if they would extend the time?
The other appellant.
My last discussion with the representative from the association is that they will most likely request a refund because they need that money to use it for expert review of a new traffic impact analysis, a new geotech that will be coming, and then they'll have the ability to do, based on whatever happens at that new remand hearing, if they want to do a new appeal, they can do it at that time. So I think that's what's going to happen.
So for me, again, I think I would be happy if we reached out to them and said, can we get a letter that says you'll extend the time so that we can comply with our code rather than just saying, "Eh," because it is written in there that it says shall. And
Commissioner Borowski, if
Yes.
can I interrupt you for a moment? Are you anticipating that that would happen before Planning Commission makes a decision on this order?
no, at some point, before the end of the 45 days, before the time runs out, would be what I would hope.
I guess I have a follow-up question about that.
Okay, well, I had Commissioner Ramey in the queue. But can I ask a clarifying question? Because I maybe it mixes more. If they were to withdraw their appeal, get a refund, and then we end up in the same place we're at, however many months from now, because this was kicked back, have they missed the window of opportunity to go ahead and appeal the original application? I think, is that what does that make sense? So if we say, yes, we'll go ahead and put these on hold, but then they choose to just go ahead and withdraw their appeal, do they miss their opportunity to appeal because of a time issue?
There would be an opportunity for anyone who participated in the remand decision in front of the hearings official, which could be anyone because we'll reopen the record, to appeal that decision. So that remand decision will be based on an amended application, but we believe that will then be the application that's in play. The application that has been in place so far will be so substantially changed that these appeals, for the most part, won't make sense anymore. A bunch of the appeal issues will probably change.
Okay. Commissioner Fragla, I'll let you, because I think
So
it's relevant to this.
if they remove their appeal and get a refund, then the 45 days would no longer apply, correct? And so but based on the explanation you just gave to Commissioner Edwards, they do have the opportunity under the new process with the hearings official to appeal.
Okay. Commissioner
that-
Ramey, go ahead.
This one seemed like the least clear of all the issues. And so the thing for me about there isn't any precedent to put something on hold, that seems like an odd idea. And there's nothing in the city code that allows that, I think. So I'm not sure if there is or not. But that aside, the timing of it and the clock for the appellant who is the Laurel Hill Valley citizens at this point, I think you've answered the question by saying that the ORS sort of trumps the city. If you're required to do something by the ORS statute that conflicts with your own code, you got to go to the statute first. And so that forces our hands in saying, okay, well, that's going to be an appeal that we're going to put on hold. And then the 45-day clock is going to expire, but that's not an option that we have. So that's the one scenario. The second scenario was the one that you just went through with Commissioner Edwards, which seems like what we're hearing, and I think what was in some of the documentation we received is that the reapplication is going to be so different that all parties, or at least the citizens, are going to want to step back and have a whole nother run at a whole new application. So for them, it's going to work. And so that was really my concern about this, is the concept of putting something on hold. What does that do to the clock for the citizens? And then do they have an ability to come back if somehow LUBA says, whoops, sorry, you're back to square one again? But I think your answer to our chair, Commissioner Taylor, wow, I was so close, Commissioner Edwards, really satisfied that for me. So I think given it's a very nebulous kind of issue in front of us, but I think we've walked through the scenarios for this particular application, this particular set that faces us, and I'm okay with what the staff has recommended in this case.
Commissioner Baker?
Yeah, I'm relatively comfortable with 4, but I had one other question, just a clarification. So if the applicant decides to, is the applicant allowed to unre-invoke this thing during the process?
That's a great question. I,
You know, and that was like my repeating, can they be
can they
invoked?
invoke it a couple of times? Yeah.
But this one is a little more of the beginning process rather than.
Again, we don't really know. We don't have LUBA or Court of Appeals decisions on that point. I would vigorously advocate that you get one bite at the apple. This is a one bite at the apple kind of thing. And so doesn't give the applicants a chance to propose a series of amendments, and it doesn't give an applicant a chance to amend and then renege and amend and.
You answered that last time, but I was more about what happens if they decide to pull their application, what happens to the process?
When you say pull their application,
And they uninvoke 197.522.
They would drop their appeal.
No, they would
if the
go forward with their appeal.
Right.
Yeah.
so if the applicant
Right.
decided not to somehow to uninvoke 197.522.
Is it possible to uninvoke it once it's, in other words, did they file their fee or did, is there any?
It's a good question. I would say at this point,
I mean, it's unlikely that they will
Right.
uninvoke, but just so we know, if they change their mind and how they're going to approach this.
I don't think the statute says much about it, but I will say that, at this point in the process, given the hearings official's denial on a bunch of different fronts, it seems unlikely to me that the applicant would want to continue with that structure of the application, because they're unlikely, obviously Planning Commission could do something different than what the hearings official did, but based on the number of reasons for denial, the likelihood of a denial at Planning Commission seems reasonably high. So I don't know why the applicant would want to go back to that initial application. But that's just my 2 cents. I can't speak for what the applicant wants to do.
So in other words, I mean, I agree with you in this case, but I'm just trying to get an idea whether it's possible to uninvoke this and then mess up our process.
Well, my hope is that before I come back to you again on this issue, we might have some more clarity from LUBA or the Court of Appeals, or the legislature, or whomever, or that might be kind of another one of those issues that is outside the scope of this conversation, but is part of a larger legislative conversation about how the city looking forward wants to handle these types of invocations, and if it's possible for the city to put some bumpers on that, and et cetera.
Okay. Sorry. All right, does everybody have their questions answered and feel that they're ready to do a straw poll on procedural issue number 4? All right, I will ask of the commissioners, all those in favor of staff's recommendation on procedural issue number 4, which is to put current appeals on hold. All those in favor? Any opposed? All right, we have 6-0 in favor. All right. Okay, so that brings us then, I guess, to the draft final order. Oh, do you have?
Oh, you have it.
So, yeah, I have a motion.
Oh, you do, okay. Well, I will then entertain,
I'm sorry.
that's okay.
May I interrupt?
You
So,
may.
Just for Planning Commission's information, there are, I believe, 2 or 3 very small, non-substantive changes between the December 30th version of the draft final order and the final version that we're asking you to adopt, that Dan has in his hot little hand.
So this is not it right here.
Well, so the changes are this. On page 5, there was a typo. We accidentally missed a 3. So instead of EC 9.715, it now reads EC 9.7315, which is the correct citation.
See that?
At the top of page 6, kind of 2/3 of the way down the paragraph, there was an and slash conditions that should have been and or slash conditions, so added in that or. And then changed the date on the order to this January 6th instead of December 30th, and changed the signature to Chair Edwards instead of Vice Chair Fragala, because Chair Edwards is here tonight. So those are the changes.
Okay. I will then entertain a motion if there is one.
So I move to adopt the final order of the Eugene Planning Commission on procedural issues related to the hearings official's decision on the Laurel Ridge tentative PUD application, city file PDT 18-3, including the revisions that were just stated.
All right. Any discussion?
I'll second it.
Okay. Commissioner Bobrowski seconds it, and comment?
Yeah, I just wanted to speak to the process. Again, thank the commission for indulging me on some of these procedural issues. I get into them sometimes, and I just want to make sure that the questions get asked and answered to the best of their ability. With regard to this development, this isn't the first time I've seen this development brought before us. And for me, it's a large chunk of land inside the urban growth boundary that's zoned for housing. It's a very nice neighborhood. It's adjacent to the neighborhood that I live in. So I have concerns about how it's going to be developed. I just hope that at some point it can be developed in a manner that is applicable to both a developer that can make it pencil out and to the neighbors that have to live with the impacts of these types of developments. I'm sorry that it takes so long and so much money to go through this process. That's me personally. There was stuff in the record that there's been over $3 million spent trying to get a shovel in the ground for this area, and that's disturbing to me as a planning commissioner, because we know that there's a housing issue in our community, and so I think that this code that we're dealing with here and this statute from the state was a stab at trying to be able to make things work. It's like, okay, you went at it and it didn't quite meet it, so take another bite at the apple. So I'm hoping that this process can do that and make it work for the neighbors, make it work for the developers, and make it work for the people in our city that need housing. So I just wanted to say that before the vote.
All right, thank you. Anyone else? I just want to say I echo Commissioner Bobrowski's sentiments about this, this development, and just reading through all the materials and being relatively new to it, because I wasn't, here when the different times that it came before the Planning Commission in the past. But definitely, for me, it illustrated why it's so important that we continue to work on some of the things that we're already currently working on. The clear and objective standards and, the tree preservation standards were a big part of that. And we kind of left that in limbo because we really didn't land anywhere with how to move forward on that. But this is a really, to me, a perfect example of why it is so critical that we have a process that can be, remove the subjectivity and just the complete ambiguity to so much of it. When I'm looking at 75 acres inside our UGB that has been earmarked for housing and development, and, the whole reason that we even have UGBs in the first place is to preserve farm and forest lands, among other things, but that are outside of those lines. And so when we're treating areas inside those lines, it's just the same way we would, that are not earmarked for housing and development, I feel like we have work to do. So I think I look forward to continuing to do this work. So I will just say that. And with that, I will call for a vote. So if anyone else has nothing else to add, all those in favor of the motion? All right, any opposed? All right, the ayes have it, 6-0. Commissioner Borowski.
One more question. This is outside of this thing. This is just can you give us any update on the Simons appeal from Luba?
I can. The decision has been appealed to the Court of Appeals.
Right.
Oral argument is
You
scheduled.
might want to make them aware of which one that is. Do you guys all know which one we're talking about here? So this was the one that when it was the site review on those properties in the Whitaker that we said site review applies. That got appealed up to Luba, and Luba remanded it, and now you can take over. Because I just wanted them all to be on board.
Also in the paper.
I feel like you even need me. So
Correct.
that is all correct. Luba remanded. The city appealed Luba's decision to the Court of Appeals. Briefing has already happened. Oral argument is scheduled for this Thursday. And the Court of Appeals then has up to, I was saying, it's either 90 or 95 days to make a decision unless they give themselves more time. But they usually make the decision within that time.
And I just want to note that your next scheduled meeting is Monday, the 27th of January. It's a 11:30 meeting. It's about clear and objective, and I believe trees may be on that agenda. If not that one, then the very next meeting. So clear and objective will be coming back to you. I think we've got you scheduled for 2 meetings to walk through some of the code changes on that.
And I had a question about that. So do we have some direction from council as to what they would like for us to look at? when we
Yes,
do
and
that?
you're going to learn all about that when you get your agenda
Okay,
item
great.
summary. But council did look at it. They did say, hey, we want this to move on to the next steps. But if you could go back to planning commission on a couple of things, one of them being trees, and I'm blank.
Transitions.
Yeah, I think transitions was another one, and then maybe the 300-foot setback. So you'll be seeing some of that. And I think there may have been 4 things actually, but yeah, trees for sure. So that will be coming back to you. The first meeting on that is January 27th. So
We'll look forward to that. All right, anything else from staff or commissioners? Commissioner Baker?
I just wanted to mention that the Historic Review Board met, and there was another local historic landmark established for, looking for my notes, which I have here somewhere, but this pile of paper. It was a dean of the architecture school, Dean Harris, and it was the house that he built up in the South Hills. It's an unusual house, and it was awarded a local historic Eugene City landmark for the house, and it provides some protection so that the house later on doesn't get so remodeled that you wouldn't, recognize the exterior.
Okay. All right. Well, with that, I'm going to go ahead and adjourn the meeting. Thank you. Thanks, you guys.